I have just found out about a significant update in California legislation, and I found out through the ADA Title 3.com blog from Safarth Shaw, and I've currently got this pulled up on screen share, and I will link to this post below. I wanted to read one thing from this blog, and it's titled "New California Assembly Bill on Website Accessibility Could Result in a Lawsuit Tsunami." So the blog at the very top, it says, in a classic gut and amend move midway through the legislative session on June 12th, the California Assembly's Judiciary Committee replaced the entire content of an existing bill on courts, AB 1757, with language that would effectively make WCAG 2.1 Level AA the required standard for websites and mobile apps of business establishments covered by the UNRRA Civil Rights Act. And now I'm going to tab over to the bill text itself, and this is AB 1757. And so, as Safarth Shaw said, there is language that is for a bill on the courts, and that language is in red and it has been crossed out, and the new language is in blue, and that speaks to digital accessibility. So I'm going to scroll down and read from a few selections, and the first is letter B, and it says, to be entitled to statutory damages for internet website inaccessibility, a plaintiff must prove one of the following. One, that the plaintiff personally encountered a barrier that caused the plaintiff to experience a difference in their ability to access or use the website as compared to other users, such that the plaintiff was unable to acquire the same information, engage in the same interactions, or enjoy the same services with substantially equivalent ease of use, or to have the same level of privacy and independence as others who are not disabled. Two, that the plaintiff was deterred from accessing all or part of the website or the content of the website because the website's failure to provide equally effective communication or to facilitate full and equal enjoyment of the entity's goods and services offered to the public. So first, thoughts on those two ways to be entitled to establish statutory damages. That those two ways that plaintiff must prove this. Um, that's going to be very difficult to defend against, because if we say a barrier that caused plaintiff to experience a difference in their ability to access or use the website, that's really subjective, and it's going to be difficult to disprove that the plaintiff did not experience something. Um, and then two, that the plaintiff was deterred because of the from access because of the website's failure to provide equal communication, effective communication. Again, that's difficult because we're trying to we're trying to disprove something that is subjective to the plaintiff. So if the plaintiff was deterred, they were deterred, right? Like it could happen, and that's going to be very difficult to defend against. Now, um, on on letter E of here, and this might be a subsection, but it says, for the purposes of this section, the following definitions should the definitions apply. One, entity means a business establishment that is open to the public, a public place, or a place of public accommodation. Two, internet website includes all internet web-based technology, including but not limited to a mobile application or app that can be accessed by a mobile device. So I think that effectively lumps mobile apps with websites, although they worded that strangely. And then three, related accessibility standard means the Web Content Accessibility Guidelines, WCAG 2.1 Level AA standard for the accessibility of internet websites. Okay, so the there are so many details that are glossed over here, and so this just makes it incredibly difficult to defend, because what if you have a website that is fully conformant with the Web Content Accessibility Guidelines, save for a few technical issues, and those issues, like let's just say something that could be very slight, like having a 4.3 to 1 contrast versus a 4.5 to 1 contrast, which is the required threshold in the Web Content Accessibility Guidelines. Um, that's something where a plaintiff could technically argue that they were deterred from accessing the website's content because there was color contrast that arguably was not sufficient, and they didn't want to um, continue with access to the website because it was they were deterred. So this is as Seyfarth Shaw said in the title, this really is favorable to plaintiffs and plaintiffs' law firms. Um, and it's effectively requiring conformance with the Web Content Accessibility Guidelines 2.1 AA. And so that's really the best practice, and that has been the best practice. Nothing changes, but now this is more concrete, because whereas before we were working with this ambiguous flexibility that the DOJ at one point has stated that these entities have, the places of public accommodation have. Now the standard is adopted, and there are many more technical questions here, but this has been what has been WCAG 2.1 AA conformance has been best practice now for quite some time, and at this point it is now imperative that you work through and make sure that you resolve as many of or you conform with as many of the success criteria as possible. So you need to become familiar with the Web Content Accessibility Guidelines as soon as possible. Of course, this is not imminent. This doesn't mean that the bill will pass. It just means that this is proposed and is up for approval. But you can get ahead of this right now and start working towards full conformance. And it's not as if you shouldn't already be very you shouldn't already be concerned with accessibility, because litigation is ongoing. This does not really clash with existing litigation. Rather, this tacks onto it. So this really puts pressure on not only website owners, mobile app owners, but anybody that is developing apps, anybody that is creating websites or building websites, and possibly anybody that is also providing integrations that can be used on websites, right? So just think of a social stream widget, for example. If there's a way for someone to embed Instagram posts on their website, that could be potentially implicated. But as I said, there are so many more details and questions, and so this language is fairly broad and general, and so it's just not that easy. And when you start to work through this in practice, but that really gives the advantage to plaintiffs' law firms and puts website owners and mobile app owners and developers on the defensive. And so I would view this bill as an opportunity to go ahead and just try to make my digital assets conformant with the Web Content Accessibility Guidelines as much as possible. Of course, WCAG is for the web, right? It's the Web Content Accessibility Guidelines, but those same principles can apply to other digital assets such as mobile apps. So this is a time to become familiar with the Web Content Accessibility Guidelines. Train your web team, your digital personnel, everyone that's working on content, adding content, uploading content, everyone that's working on code, adding new code, editing, updating code, this is the time to train them. So I already have a course on the Web Content Accessibility Guidelines. I will link to that below. It's at wcagcourse.com. That's WCAG course.com. And then I also have a course called the ADA Compliance course, where this course focuses on the most commonly litigated website accessibility issues that are frequently claimed in litigation. And so the lessons in this course are comprised of those accessibility issues. And by the way, those are also, many of these issues um, are also really effectively requirements under the Web Content Accessibility Guidelines. So you will work towards conformance, but you will prioritize conformance in a way where you are resolving the accessibility issues that are most commonly litigated. So I'll also link to the ADA compliance course below. But to summarize here, this is proposed legislation that is up for approval. It would increase this if passed. This would, if approved, this would increase litigation significantly, and I think you would see more plaintiffs' law firms enter into this space. And you have to keep in mind that while this is a state bill in California, it would effectively apply across the US and presumably even internationally, because this applies to all businesses that can be accessed from California. And as this applies to websites and mobile apps, those websites and mobile apps can be accessed from anywhere. And so obviously, this is open to all websites and apps that can be accessed in California. So significant update, but none of the recommendations change, right? WCAG 2.1 AA conformance has always been best practice, but if anything, awareness of this bill gives you this. I would see this as my opportunity to get ahead of this. Eventually, we were going to see, whether it's this bill or another law or another regulation, eventually we are going to see digital accessibility mandated. So whether or not there's a window for different places of public accommodation to become in compliance, I would use this time while this bill is up for approval to go ahead and start right now.